Good afternoon, everybody. I'm Susan Howards, a local domestic violence attorney here in Brookline. And I just want to remind you that October is Domestic Violence Awareness Month, and the Jennifer A. Lynch Committee is hosting a vigil tomorrow, Thursday at 4:30 behind the Health Building. We'd like to see so many of you attend. Because it's Domestic Violence Month, we're doing something special today. Brookline Interactive Group has been so gracious over these many, many years to allow us to host the Safety Net, a show dedicated to educating and raising awareness of domestic violence. And today we have a most special guest, Shakesha Coleman, who has completed graduate work in public policy, education, social work, and law. She's an experienced educator, trainer, mediator, licensed clinical social worker, and a Guardian Ad Litem. Her background and professional experience make her an exceptional advocate and problem solver, especially concerning the intersection of law and mental health. And Shakesha is with us today, mainly in her role as a Guardian Ad Litem. And I'm going to ask her to add Guardian Ad Litem in situations with domestic violence. I would like her to focus on that if she could. Welcome, Shakesha.
Thank you so much, Susan.
Shakesha, what is a Guardian Ad Litem?
A Guardian Ad Litem is a neutral party that usually a family court judge appoints to be the eyes and ears of the court. So the Guardian Ad Litem's job is to give the judge, usually in a family court matter, a neutral perspective of what's going on in the case so that the judge can determine what would be the best ruling to serve the best interest of a child or the vulnerable party being protected. So the Guardian,
are you talking about divorces? Are you talking about separations? Are you talking about anybody who walks into probate court, elderly, young? Can you sort of just elaborate a little bit?
Absolutely. So usually a Guardian Ad Litem is appointed by a family court judge to protect the rights of a vulnerable person. Usually it's a child, such as a child in state custody. So usually it's a child that is a ward of the state, or somehow the Department of Children and Families has custody of that person. It could be someone that the judge has determined is of diminished capacity, someone who may not be able to understand the proceedings and may need assistance with that, or may need their rights protected because they don't understand the proceedings. So a Guardian Ad Litem is usually appointed by a family court judge to protect the interests of a vulnerable person. And so
I'm sorry, if I'm in family court, I'm not a family lawyer, but if I am in family court on a domestic violence issue, can I request that a Guardian Ad Litem be appointed, or do I have to wait for the judge to suggest it?
You can. So a lawyer can suggest or request a Guardian Ad Litem be appointed. Usually it's for a vulnerable person. So in a domestic violence situation, the guardian would be, for example, to determine if a parent can have visitation rights. So a Guardian Ad Litem assists the judge with evaluating a narrow legal issue.
Okay.
So the third party may be appointed, for example, to determine, is this parent harmful to this child? Should this child have visitation with this parent? It may be a situation where the parent was once determined to be abusive to the child, or once neglected the child, or abandoned the child, or exposed the child to domestic violence. And so in a domestic violence situation, a family court lawyer on behalf of their client can say, can you appoint a Guardian Ad Litem to determine if my client can have visitation with her child? I know this person, may have exposed, their child to harm by, maybe having them witness something. But can you have the Guardian Ad Litem look at whether or not those circumstances have changed, and now this person can be in contact with their child despite what's happened in the past?
So the judge gives you your marching orders, am I correct?
Yes, that is absolutely correct.
What you can do and what you can't do. I mean, the boundaries of the, I guess I'm going to call it investigation. But
That's
what
right.
if you find something that's unusual and you want to go beyond what the judge has ordered you to do? Can you do that?
That is an excellent question, Susan. And Guardian Ad Litems have some leeway because we are mandated reporters. So if we determine that it's necessary to exceed our scope, we can ask the court to still hear us. So a Guardian Ad Litem can ask to be heard. A Guardian Ad Litem can say, hey, listen, this is what I found, specific to this issue you asked me to look at. But Judge, I'd also like you to look at this additional issue, and this is how I think it relates. It has to relate to the matter at hand, and it has to be pertinent to the specific issue that the judge asked to be examined.
I know from my experience as a domestic violence attorney, I'm not a family law attorney. Sometimes I disagree with the Guardian Ad Litem's findings. How do you, and I disagree rather vehemently because it's going to hurt my client. How do you handle that? And do you expect it?
I do expect it. So sometimes we are not very much appreciated, Susan. And what people need to understand is that although we do wield some power, the judge does not have to accept our recommendation. The judge can, yes.
The judges do accept your recommendation.
Sometimes they do. Sometimes they do, but sometimes they go rogue. They go out on their own and they say, thank you. I'm not sure I agree. But yes, usually a judge is appointing us or accepts our, the request for our appointment because they're going to listen to us, but they do not have to accept what we say. And I want to say this, it behooves the attorneys, the actual parties in the case, to work with the GAL. So one of the things I usually make a part of my work is I'll ask the parties, usually in front of their attorneys, is there anything in particular you would like the judge to know? Because as the eyes and ears of the court, it's my job to give the judge information they may not otherwise find. And so I think sometimes there may be a little tension between a GAL and an attorney because they're not using that GAL effectively. We can help you.
What if I think you're not helping me? And you present your report to the court, and she or they rule unfavorably for my client? What is my recourse? Can I appeal a GAL ruling? Can I get a new GAL? Can I ask? Listen, get Shakesha off this case. I know her reputation.
Yes, you can. Yes, you can. Attorneys can strike GAL reports. You can strike a portion of our report. You can have us removed. There is an appeal process. You do not have to accept us. But it does ultimately go before the judge. So you would make a motion just like you would make a motion for anything else. You can make a motion to strike my report. You can make a motion to strike something that I testify to. You can say, I don't think this person is partial, or I don't think this person has the requisite background. I want a new GAL. It's happened. I know for a fact that these things have happened.
It must be very, very uncomfortable though if it happens, isn't it?
I
would be reluctant to do it, to be quite frank. I really would.
It is uncomfortable, but it's a risk that we take. These are very delicate matters: child custody, domestic violence, child support, visitation. These are very personal matters. There's a lot of unresolved trauma involved, but this is what we sign up for. I know that sometimes lawyers are looking at my role in somewhat of sort of an adversarial way. But like I said, you can use us. We can work together. We can help you. We can help you because our report goes to the judge, and you get to make sure we're doing our job.
What exactly? Go ahead. I'm sorry to interrupt. Go ahead.
No, I was just going to say, there is a checks and balances system.
That's good. What exactly does your investigation, just sort of off the record, what does it consist of? What do you do first?
So the first thing I do is I look at the docket report. I look at who's involved. I look at who the mother is, who the mother's attorney is, the father's attorney, because the first thing I want to do is I want to talk to these people, because usually my investigation is going to cause me to have to talk to these people. If the judge says, well, should this father be allowed to speak with, visit with this child because there's been an allegation, founded or unfounded, of abuse? Should this child be allowed to visit with both parents or one parent? Well, guess what? I need to talk to the child if the child is old enough. I need to talk to the mother. I need to talk to the father. I need to talk to maybe teachers. I need to talk to people who know this child, who's familiar with this child's behavior. Usually with a packet, with an appointment packet, usually there are reports involved. So it could be a court investigator's report. It could be a report from the Department of Children and Family Services. So I read all of that information, but the most important thing I think I do is I talk directly to the parties. From your standpoint, what's going on? I ask the attorneys, what's your position on this matter? What would you like to see happen?
And do you, what's a court, and how do you differ from a court investigator? You're the same thing.
So we're actually not the same thing, because we are neutral parties. Guardians Ad Litem are neutral parties. We do not represent any of the parties. We're not here, although we are here to give the judge a bird's eye view of what's going on. We don't represent the Commonwealth per se. We don't represent the court per se, and we certainly don't represent any of the parties. So the court investigator's report is simply to assist the judge, while a GAL's report can assist everyone.
Ah, good, good. That's a really clarifying answer. I never really knew that. What don't you do? What don't GALs do?
That's
should not do. What
right. That's excellent. So so we do not represent parties, even though most of the time we are attorneys and we do have a legal background and certainly other training. We do not represent parties. So we do not argue on behalf of one party or another. Now, here's where there becomes a little tension. And this is why I think sometimes people don't appreciate us so much, because sometimes the information that we present, sometimes it is more helpful to one party than the other, but that's peripheral. And sometimes that's why people, have a little issue with us, because sometimes it may seem, because of what we're recommending or because of the information we find, it's easy to kind of confuse us as, oh, you're on this person's side. Well, my report, if I find something adverse, it may seem adversarial to one side, but that's not my job. It's like, if 3 + 4 is 7, it's just 7. I didn't do anything to make the 4, make it add up to 7. It's just, if it walks like a duck or quacks like a duck, it's a duck. And I'm sorry that your client's the duck. I'm sorry.
Exactly. Me too. How long does a typical, and I don't even know if there is a typical GAL report, because I would imagine every case is unique and different, but how long would you say your investigation takes?
It usually doesn't take more than a couple of days if I can get all of the parties to talk to me rather immediately. I usually start my investigations maybe a couple of weeks before the report is due, because I don't want to turn it in too early in case something happens, and then I would have to revise my report. So usually an appointment letter is given to a GAL about a month or two before the actual court date. Also, GALs don't always have to write a report. Sometimes we're simply appointed, for instance, in a diminished capacity case, sometimes we're just appointed to assist an attorney. But in a domestic violence case, which I know is what you're more interested in those instances, we usually would have to actually write a report. Is this parent fit to be, to have visitation with the child? Has this parent improved since the last time, they were court involved? But usually it doesn't take very long if you can get the parties to meet with you rather soon. But it's always best to start at least a couple of weeks before the court date, because lawyers, very busy people, you may not be able to fit me in the day before the court date or the week before the court date. So we'd like to start the investigation or information gathering as soon as possible, but sometimes we're writing those reports right up until the day before the court date.
How long are the reports usually, or does that vary too? Is
It
there a
does.
limit?
There's no limit, there's no minimum. As long as we give the judges the information they need, it's a GAL report. I find that on average, my reports are about 5-6 pages, but they can be longer, they can be shorter.
Are they confidential? Is anybody allowed to
They
see
are.
them?
Only the parties are allowed to see them, and the judge has to give permission for the reports to be released. So when a GAL completes a report, that person turns the report into the court, and the court releases it to the parties or gives the
But do
GAL.
they release it, Shakesha? Do they release it, or I've had to go in and look at the file and look at the report there. Can't make a copy, can't this, can't that, blah, blah, blah.
So my understanding is that the report is confidential and it's only for the parties. And also too, courts have different rules, even throughout
Okay.
different, even within the same state. Some courts do things a little differently depending on the town or the city. But generally, the court report gets turned into the judge, and the judge will tell the law clerk when they can release it to the parties.
So to go back to my question, what can you absolutely not do?
We cannot
anything.
argue, right. So we cannot argue for a party. We cannot, we also cannot, we cannot repeat something that we haven't without offering what's called a lamb warning. So a lamb warning is where we tell the parties right up front before we start talking to them, anything that you tell me can go to the judge. And so that is something that GALs are supposed to provide to the people that they're interviewing before the interview takes place. And so as an attorney, you need to make sure that the GAL gives your client that warning, because your party needs to know that whatever you're telling me, the court, if this is going to go to the court, and the court's going to use this to make a determination. And that's why the attorneys are there. So one thing that we shouldn't do is we should not be talking to your party without you, the attorney, being there.
Okay.
Not do that.
Shakesha Coleman, this has been so interesting because I've dealt with GALs not always nicely, but I think in the future, I will let them know that you are certainly appreciated because your job is not easy. You're on the hot seat more than
we are.
Yeah, you are. You are. So Shakesha, one last word that you'd like to say for Domestic Violence Awareness Month? Anything you'd like to say?
Well, because I'm so interested in the intersection between law and mental health, I would just like to encourage people to get their mental health in order, because sometimes we get ourselves into situations when we are not whole, when we have not resolved our own trauma. And the best way to stop hurting other people is to resolve trauma. And so that is what I would say to people. Keep your head up, hang in there, and just always be on a path of improvement.
Shakesha Coleman, thank you. And make sure that you send your contact information to Ann, our producer director, who made this happen. Thank you, Ann. So that if people want to get in touch with you, they can.
Sure.
Thank you again. And if you're in Boston, I hope I'll see you at the vigil tomorrow.
Okay. Thank you so much, Susan. I really appreciate you having me.
My pleasure. Thank you, Ann. Thank you, Shakesha. Bye for the safety net.
Thank you. Thank you so much.